Nick Caprino, I want to welcome you to Marcy's Law, Why We Do What We Do interview series. Thank you so much from the outset for agreeing to do this and for all the great work that you do in Kentucky. We have been the last few interviews celebrating the 5-year anniversary of Marcy's Law's passage in Kentucky, and we've had the privilege of having the first assistant Commonwealth attorney from McCracken County, Amy Clymer Hancock, talk a lot about how the prosecutors have been working with Marcy's Law and how it's helped them to continue to create a trauma-informed, victim-centered culture throughout the court system and throughout the prosecutor's office. And then Emily Bonistal Postel, who introduced me to you, who is our state director in Kentucky, talked about all of the great things that she's been doing with Marcy's Law and with great partners like yourself and the Children's Law Center. And one of the things that we wanted to try to get across is when we pass Marcy's Law in a particular state, it starts as a campaign like any other campaign. But once we pass Marcy's Law, which we've been blessed to do with the help of community partners like yourself throughout campaigns and through the citizens through a vote at the ballot, is we stay and maintain a very strong presence in the states where we pass Marcy's Law, because we want to make sure that Marcy's Law works the way that we had said that it was going to work and continue to grow and listen to each other and build momentum with great partners of like mind to create a trauma-informed, victim-centered culture. So thanks for doing that, for all the work that you've done. Emily just absolutely loves the great work that you do and pointed me in the direction of your organization and specifically you. So thanks for doing this. We are coming up on at the end of the month and tomorrow, well, in a couple of days, we begin April, which is National Child Abuse Prevention Month, which is really centers around the work that all of you do at the Children's Law Center and then some. So welcome, Nick. And if you could first tell us a little bit about what the Children's Law Center does and then your journey as an attorney, and how you got there.
Absolutely. First, thank you, Peter, for having me and lifting up Children's Law Center. And thank you for everyone in the audience or watching this for the work that you do. It's extremely important. I know that firsthand. I really love talking about what we do. So yeah, Children's Law Center, we are headquartered in Northern Kentucky, Covington, Kentucky. We are a unique nonprofit law firm. We have offices and attorneys in Lexington, in Cleveland, and we're soon to have some attorneys in Louisville and Columbus as well. And like the description says, we're kind of a unique law service. We provide legal services, civil legal services for kids across a variety of issues. We provide all those legal services for free, no cost to the kids or their families. And we do that in Kentucky and Ohio. A lot of what we do is representing child victims of crime, representing kids who have experienced abuse, have parents who are experiencing substance abuse issues. We represent them as victims of crime. In the criminal cases against their perpetrators, we represent them in child welfare cases, dependency, neglect, abuse cases. We represent them in high conflict custody cases, a variety of different issues that will represent kids that are being victimized. Additionally, we also represent kids on a lot of education issues. When kids are seeking special education rights, maybe some disciplinary rights, usually both of those issues intertwined. We represent those kids. In Ohio, we have a program where we are representing young people to help overcome legal obstacles to safe and stable housing. And what we kind of one great thing about our work is anybody who's doing this knows that when they're faced with a client or a child that has one of these issues, it's not just one of these issues, right? It's other issues. So we can use our expertise in different areas to kind of work across different legal areas. In addition to the direct representation, we advocate for policies that benefit kids across Kentucky and Ohio, and we engage in a lot of community education, educating families, kids themselves, legal professionals on how they can better lift up and empower kids in the court process.
And one of the things that you talked about is how many of the kids, sadly, that you have to help exhibit across the board a lack of agency and a lack of control over their environment coming from a chaotic situation. If it's right after they've been victimized, or even if it's their upbringing in general, and then a specific instance that brings them into the courtroom as a victim of crime. Tell us about your journey as a
Mhm.
lawyer, and some of the experience that you've had that have given you an opportunity to be successful at what you do as a representative and an advocate for children.
Absolutely. Yeah. I feel that I have a relatively unique kind of precursor to my experience representing child victims. I spent the first 8 years of my legal career as a public defender. Um, and that really gave me some insight. The clients that I represented often exhibited and experienced a lack of agency over their environment, not able to make the changes, things happening to them. And for a lot of my clients, I was able to detect a pattern of having a childhood that was may have been filled with chaos, different types of chaos. But essentially, the idea is that things are happening to them and they did not have the control or power or agency to kind of change the environment to something that was healthier for them. So when the opportunity at Children's Law Center came up, I jumped at it because I saw that as an opportunity to help kids have that empowerment and agency. And I've been able to do that in my representation of child victims of crime. That's actually one of the most fulfilling parts of what I do is giving kids who have are almost certainly in front of me or in front of the court because they've had their agency stripped away from them, and trying to do everything I can to give them a little bit of that back.
Yeah, and you're so effective at doing it, probably in large part because of your experience as a public defender. And when Dr. Emily Bonistel Postel was talking to us, one of the things that she and Amy Clymer Hancock was talking about was a law review article that Dr. Bonistel Postel has authored, and it talking about reducing re-traumatization in the court process. That's obviously prevalent throughout the process with witnesses and victims, especially with children, I would think. When you and I have gotten to know each other, you've given me a little bit of a different take on it, a little bit of a different twist, which is rather than looking at it as reducing re-traumatization, and there's a strong presumption that a child victim would be re-traumatized, but for someone like you who prepares a witness in a way that the re-traumatization could also could almost turn into an empowerment and an empowering exercise. Tell us a little bit about how that works, how you can prevent re-traumatization by empowering child victims. Especially, I remember when um, you were telling me that when you first meet the child victim, how powerful that can be, and you start to earn their trust. And one of the things you say to them is, "My only job is you." Tell us about
Yeah.
that process and how that empowers a victim and how that makes them feel.
Yeah, thanks. And I'll kind of build up to that. My one of the benefits of my experience is I am as a public defender, I am very familiar with the criminal justice process, at least in Kentucky, and also in Ohio as well. And I'm able to pull back that curtain a little bit, that curtain that is in front of our clients and their families when they are not up against the system, but they're facing the system and they don't really understand what's going on. Usually not for malicious purposes. It's just a system that's difficult to understand. So I can take that first step and kind of pull back the curtain, open that black box up a little bit to say, hey, this isn't as scary as it seems. Here's what we're looking at. And in that first meeting that I often have with my clients, I talk with them and I say that very thing that you just pointed to is that you're my only job. The prosecutors, they have, their job is in a lot of ways much harder than mine because they've got a lot of different interests to balance. Um, I just have yours, and I am here just for you. Sometimes that's an alignment with one side or the other. Sometimes it's just them, and they are expressing their own feelings in the way it is. But I don't really have to worry about who it's in alignment with because I'm just worried about my client's interest and what they want, and more often what they want to know, more often than wanting a particular outcome or wanting a particular thing to happen. They just want to know what's going on. And that is something that lawyers can really take for granted because we live it, we're in it every day, and what is going on is kind of um, really easy for us, so we forget to explain that to clients. But when I do explain that to my clients and at the same time build that rapport to really not only just tell them, but show them, hey, I'm here for you. You're in a way my boss. I may be the one with the legal degree, but you're telling me what to do. I start to see that anxiety decrease, and I start to see that knowingness increase, which is a huge help. Um, you mentioned also too the presumption of re-traumatization, which is something I'm abundantly aware of, and we are always on the lookout for. But I also try to make sure I'm not assuming there will automatically be re-traumatization, and making sure that if the kids are appropriately prepared and able to go through this process, including testimony, and if we put in all the work that needs to be put in, we can actually transform what is a potentially re-traumatizing process to something that's empowering. And I've gotten that feedback from several of my clients after testimony, the testimony that they were understandably very scared about. They felt like that they had a voice and that their voice was heard, and they were able to use it in a court system that they thought was this giant monolith that they were up against and had no idea how it worked. So that's pretty cool, and that's something I really like about my job.
Yeah, and we talked about a bunch of I told you that I was a prosecutor for many years in Boston. I was a homicide prosecutor, and we talked a little bit about some of our specific and unique experiences. And one of the you told me one story in particular about a child witness who was on the stand who was having a little bit of difficulty, and you took a recess and spoke with them, tried to get to the root of it, and it completely turned things around. Could you tell us a little bit about that story and the work that you did and the result of it?
Yeah, absolutely. So there was a lot of work and a lot of rapport building on the front end. I had a great relationship with this client. She had a lot of mental health issues that she was working through with therapists, and I was in contact with a therapist. But her triggers and trauma responses were often very unpredictable. We tried to accomplish testimonial accommodations for her, but we weren't successful for a variety of reasons. Um, and she was testifying in the courtroom with the defendant in the same room. Um, well, when she wasn't able to testify, the immediate assumption off of everybody was that, well, it's because the defendant's in the room and she's not able to do this. I made sure, based on my experience, based on the training that I've had in trauma responsive practice, to try to set that assumption aside when I did get the chance to talk with her in private and just listened. I just took a moment to really listen to what mattered to her. And it turns out the fact that the defendant was in the room while she was testifying was not what was triggering her to go into a freeze and somewhat of a flight response. It was actually the fact that she had cameras on her and could see herself testifying on screens. And that did a couple things. Number one, that helped me understand, like, okay, this is actually what's going on. And the other great thing about that is it's an easy fix, right? Constitutionally, and because of where we were at, getting the defendant out of the room during the testimony probably wasn't going to be able to happen in that moment. Turning the screens off while they're still recording the record, that's an super easy fix, and wasn't difficult at all. And in that process, we also talked a little bit more about what might help her get through this difficult testimony. And we came up with a mantra, which was super simple, but I think speaks volumes. It was just, I have a voice and I can use it. So she would repeat that to herself when it started getting difficult and she had a hard time saying what she needed to say. And then we started back in the trial. The prosecutor got back asking her questions, and she was able to say what happened on the stand. And in that case, the defendant was convicted. And I can say she afterwards was so happy about the effect that she was able to have on that process. And that was a really fulfilling moment for me, and I think for her as well.
And it speaks to your point, as opposed to you kind of flipped the re-traumatization presumption on its head and empowered her to the extent that when she was done with the process and the process was done and the case was closed, as opposed to someone who walked out re-traumatized, it was someone who felt confident and really proud of herself
Yes.
with your assistance, which is, which is a real tribute to your training and your bedside manner. You and I talk a lot about, we're both lawyers, There's lots of different kinds of places to go when you're a lawyer. There's lots of
Mhm,
areas and fields of the law, but not all of this is for everyone.
mhm.
Um, and you really have a special and unique talent. We're really blessed that you do what you do.
Thank
Now,
you.
from a practical standpoint, you mentioned for constitutional reasons, you couldn't have the defendant leave the courtroom. I think I know it gets very tricky when you're trying to address um, all of these. You're trying to balance all of people's constitutional rights and constitutional protections, the feelings of a particularly uniquely vulnerable victim who could be triggered and have mental health issues and things like that. Um, Speak for a moment. Tell us a little bit about what you do from a practical standpoint. Let's say, for instance, with respect to testimonial
Mhm.
accommodations, when it comes to the needs of the victim and balancing that with the constitutional protection, specifically the confrontation clause.
Absolutely. If I can, what I can do is actually, I'll start with Kentucky's unique law that gives kids the right to an attorney when they're a victim of crime, which gives me the foundation to be able to actually litigate and advocate for these things. So Kentucky has a law, 26A, KRS 26A.140, that mandates that children who are victims of crime have an attorney in the case against their perpetrators. Um, Now, the mandate says and says that even after an amendment that these attorneys, these guardian ad litem, shall be appointed if available. For many years, there was no funding for attorneys to do this. So at Children's Law Center, we'd been providing this representation for free and essentially one of the few, if not only, attorneys doing that. Recently, there's been funding to pay for attorneys to do it, which we think is great. It spreads the representation, and we can help train those attorneys while we're still taking some cases. But we're able to use that authority and that statute to then be able to litigate, to actually advocate for things for our clients. So what I've talked a lot about is kind of the informing clients what's going on, making sure they're aware of the process and they're aware of how it's going to work and making sure they're prepared. But we can actually take some steps in court by filing motions when it's directly related to their rights, which are encompassed in Marsy's law. And I often use Marsy's law as a strengthening for foundation to push forward what I need for my clients. One of the issues that commonly comes up is privacy. When a defendant seeks to get my client's confidential records, depending on the scenario, I can ask to delay that or stop that. Therapeutic records, educational records, things like that. Additionally, what I find one of the more interesting parts and difficult parts to litigate is testimonial accommodations. There's a lot of constitutional law that advocates for the right of a defendant to be in the courtroom when any witnesses are testifying against them, but there are exceptions. And the standards for those exceptions are very high and they must be case specific. So when I'm talking with my clients about the ability to get testimonial accommodations, and when I say testimonial accommodations, the typical way I'm talking about it is having the child victim testify in a different area, usually the judge's chambers, and having that record or played live out to the courtroom for the defendant and jury to see. But in the room with my client is the prosecutor, the defense attorney, the judge, and me, just asking the questions. As I said, the constitutional standards to be able to gain that are very high. So if I do advocate for that, I want to make sure I'm doing it right because although I want my clients to feel as safe as possible, one of the worst outcomes that we can have is my client having to testify, getting a conviction, feeling some of that closure, and then having that issue get overturned on appeal, and then they have to go through it again. So I want to make sure I have all my I's dotted and T's crossed. So I'll talk with my clients and kind of work with them. You know, we're a team on this to figure out if testimonial accommodations is something we actually need to advocate for, or if it's something we can actually testify in the normal manner. But then if we need to advocate for it, I've got the tools in my tool bag to be able to file those motions, ask the judge for permission to have those testimonial accommodations. And really what I'm often getting at is explaining to the court, Judge, this certainly is about making sure my client's not re-traumatized. But the other part that this is about is making sure we're getting the facts in front of the jury. If my client is not able to talk, for instance, goes into a complete freeze response in trial, then the testimony is not providing the purpose that it's meant to provide, which is getting the facts out in front of the fact finder, which is the jury. So I can advocate that it's not just about trauma, which to me, that's the most important part, but also to the court, it's also about getting the facts in front of the people making decisions.
Yeah, and you talk about it's a really interesting concept. When we first tried to introduce Marcy's Law to different states, and we're going to be on the ballot in Tennessee in the fall, and we do emphasize the fact that we maintain a presence like we have in Kentucky to make sure that it works as best as it can. Um, but one of the concepts that we talk about, especially with people on the defense side, is that constitutional protections in the criminal justice system, when Marcy's Law is passed and employed, is it's not a zero sum proposition. If you're giving constitutional rights to victims, you're not taking any constitutional rights away from defendants. And I think that's really important. The way that you just described that is we have confrontation clauses, and then we also have constitutional rights for victims, and there's a way to balance that
Absolutely.
with trained attorneys like yourself that come in and like you were saying to me at one point that you take a lot of the Marcy's Law obligations off of the
Mhm.
prosecutor's plate. As a former prosecutor, I can tell you that I know that prosecutors really, really appreciate that and will appreciate that in future Marcy's Law states. Um, if you could, I can just say, as a prosecutor, when you're in the middle of a trial, and you're trying to weigh all of the different pieces of the case and the strategy, sometimes for weeks long cases and testimony. I can just tell you how important the job is that you do, and how crucial it is for the administration of justice, because it's to weigh all of the things that has to happen from the time that you impanel a jury and give your opening statement to the time that you're giving your closing argument. What many people don't understand is all of the personalities, because these are not robots that are going up
Mhm.
on the witness stand. These are people with feelings and, like you said, chaotic upbringings. People have no agency, no control over their environment, and they come from chaotic upbringings, which are exacerbated by a traumatic event, which actually brings them to the courtroom. Uh, you and I were talking a little bit about March Madness and in sports before we get on today. And a lot of times you'll see athletes talk about how to be successful, they like to slow the game down.
Mhm.
And I think a lot of what you do is you kind of slow the game down.
Yeah.
You take away the chaos and that is such crucial work, and it's so difficult to do. One of the things I wanted to ask you as you wrap up is I know you have young children, and we talk at Marcy's Law, and we've had trainings on this as well throughout the years about the concept of vicarious trauma. The work you do is very difficult. It's very sensitive. How do you separate things um, as a dad when you look into the eyes of these children that you have to represent? How do you separate um, your private life and then the work that you have to do while um, being as effective as you possibly can, while, for lack of a better phrase, keeping it all together?
Yeah,
Sure, it must be tough.
that's a great question. And I think, there's a lot of different ways to answer it, but I think where that starts with is um a having working in an organization like CLC that really reinforces a trauma responsive culture among their staff. I think that's where it starts. And I've actually trained on this and read a lot of studies on this that staff who work in whether it's a prosecutor's office or a CAC that's doing forensic interviews or social workers, if within that office the staff and is treated with, and the leadership models trauma responsive behavior with each other, meaning making sure that when people are overwhelmed, we're actually taking actions to resolve that overwhelm, making sure that people have an appropriate work-life balance, making sure people feel connected with the mission. When the staff and the attorneys feel that, that translates to clients. And that's not just me saying it, the data backs that up. It backs it up in the medical setting, and it backs it up in the therapeutic setting. And I would definitely posit and advocate for the fact that it backs it up in legal settings as well. So I think that's the first part. I've got a awesome leader and awesome organization that really supports my ability to not take it home, right? So then I can go home and separate it. The other part I think about I'm honest with myself too. Sometimes I do get down. Sometimes I see my own kids in the plight that these kids are going through. I feel like I just kind of feel a little bit defeated to think about how I would feel if my child were in the position of one of these kids that I'm representing. And I always remind myself of what I'm doing. I'm doing something good. And I'm helping this child through it. And despite how bad what they've gone through, maybe if I wasn't here, they wouldn't even have that little hope or that little empowerment that I can give. And that really does kind of give me the energy and the pride and fulfillment that is enough that I can separate a lot of the pain with the joy and the work that we are doing and focus on that. So I could probably talk about that for days because I think that's such a great question. And I think it's something that doesn't we often talk about vicarious trauma a lot in the work that we're doing, but we don't necessarily talk about how practically to decrease the negative effects of that. So I think that's a great question, and I'm glad you asked it.
Yeah, and just to give people a sense, and you also represent clients in Ohio as well. It's not just Kentucky.
Correct.
Um, and just to give people a sense, what is your caseload on any given at any given moment? How many cases, for instance, do you have
Oh my
that you're
goodness.
working on?
So I'm probably at the moment, I'm probably somewhere around 20 or so. I'm deputy director at Children's Law Center. I've been taking on more of an organizational role, dealing with some organizational logistics. So that's decreased a little bit. I've probably been up as high as 30. Caseloads are always I always say it's a very can be a very misleading metric. It's possible to have 5 cases that feel like it's 100, depending on the case, especially in some of the high conflict custody cases that I'm working on. And then sometimes you can have a higher number, but some of them just need a little bit of touches and don't take as much work. But I think that's probably about where we're at. And that's something we also make sure we're doing at Children's Law Center. We want to be able to represent as many kids as possible, but we also recognize that if we have attorneys whose caseloads are too high, then we're not being effective for anybody.
Yeah, and let's emphasize again, and you do this at no cost
Absolutely.
the victim, to the witness. And my point about your caseload is it really takes a unique talent, a unique talent like yours, and bedside manner like we had discussed. When you have all of those cases and all of the complexities around each individual case, to walk in and to kneel down in the hallway of a courthouse and to be able to look into the eyes with all that you have going on in all the cases, to look in the eyes of one particular victim, child victim, and say, my only job is you. And to have them look at you and to feel through you that that is in fact the case. You can see why it's empowering, and you can see how unbelievably important your job is. And we are so blessed to bring it back to just have the people like you and the organizations like you and all of the experience that you bring to be able to recognize chaotic upbringings and people who can be triggered and mental health issues and work with people like Emily Bonistel Postel, who are experts in this field, who advocate for victims and families all the time, and prosecutors like Amy Clymer Hancock. It's really incredible the way Marsy's Law has immersed itself in Kentucky, the successes that we've had because of people like you and organizations like you. Um, so I want to thank you so much for what you do, for what you bring. And it's just beautiful to see, after having spoken with you, that you walk into those courtrooms and you walk in with a lawyer's brain, but a parent's heart. And that's why I think you're so great at what you do. And I just want to thank you so much for doing this today, and for continuing to work with Marcy's Law and the victims of Kentucky.
Well, thank you so much. And yeah, thank you for what you do. And Emily, to the work that she does, and all the different representatives. I mean, Emily has given me so much knowledge that I've been able to take and kind of implement in the work that I do. And like I said, the foundation of Marcy's Law kind of gives me the power and a little bit more umph that I can use legally to be able to advocate for what I need to. So thank you.
Really appreciate it. Thank you so much, Nick.
Thanks.
Have a great day.
You too.